Okay, go ahead and put us on the record, Shannon.
All right.
This is Centrum Forest Fabrication versus Robert Wood et al. Mr. Tom Burke is here for the plaintiff, Sean Carroll for the defendant, and defendant Robert Wood is present. Gentlemen, are we expecting anyone else to be present?
No, I don't believe so, Judge. No.
Okay, Mr. Carroll, this is your motion. I have read everything that you gentlemen have filed.
And Judge, I'm hearing some kind of back feed. I don't know if you're getting that too, some kind of a squeaking, like somebody's talking. Oh,
I
maybe
think
it's
it was
gone now.
coming.
Maybe we're
I think it was coming from Mr. Wood, and he's muted now, so it's
Super.
not happening anymore.
super. Judge, I'm glad the court's advised that you have read it, read everything. I expected the court would have. What I want the court to, and perhaps I probably didn't point it out as well as I should have in the employment agreement, but I wanted to run this idea as well by the court. In this particular employment agreement, the right to terminate the agreement is not just in paragraph 8, as I referenced, which talks about, in my opinion, it's unambiguous. If the court believes that that's unambiguous, then I don't think the court has any choice but to take those words as they mean. Where else do we see that language in the contract? We also see in paragraph 3, or they call it section 3, term, that the agreement shall be effective from the date of its signing until terminated as herein provided, which is referencing paragraph 8. Well, where else do we see the agreement referencing paragraph 8? Well, lo and behold, in paragraph 11, it said in consideration for the employment, comma, subject to the termination as set forth in section 8. Now, I'll bring to the court's attention looking at section 8. Hypothetically, had my client been in a car accident while working or while not working and had priority or prioritized information or information relative to this business and died, nowhere under this contract does it say the employer has a right to gather that information from his computer, his laptop, his family, etc. And if we look under the termination provision, it says that this agreement terminates upon his death. So that means that could be at any time. Why I bring this to the court's attention is if the court says, well, I don't know that his letter in April of 19 is a termination of the agreement, then there can be no doubt that the letter that was provided in February of this year is a termination of the agreement. And that agreement can be terminated at any time for any reason. I think it can be terminated even after there's alleged violations, and the contract doesn't say anything to the contrary. In fact, if we read this contract verbatim, it can be terminated at any time for any reason. And it's not just referenced there in the contract, those different spots where it says terminate the entire agreement. We know that that language is actually distinguished from places where it says termination of employment. In here, paragraph 12, for example, says either before or after termination of employment. So the drafter is distinguishing the words termination of agreement versus termination of employment. Why is that important? Because this is a termination of the agreement issue. If if the employer wants to say, well, really we meant this to be just termination of employment. No, look at what you've said in other places of the contract. You're using the words termination of employment, such as paragraph 13, again, upon the termination of employment. So there's a distinction between the two, which to me, again, makes the contract unambiguous, which also means we can't look to the intent under the more recent case that I gave you. I gave you an actual copy of it because I even went online today and I still can't get the site, Judge. Detroit Public Schools versus Waco, number 350347, 350995, references, you don't look to extrinsic issues. Page 4, when a contract is ambiguous, extrinsic evidence can be admitted to determine the actual intent. However, if it's not ambiguous, the contract has to be read as a whole. Each word, phrase, and clause must be given its effect. When it's unambiguous, the court must construe the contract and enforce the terms as written. Now, the court might say, well, does it make a lot of sense to have an agreement that could be terminated upon notice, even after an alleged violation? I don't think we can ask that question, because that would be asking extrinsic evidence. We have to look at what the contract itself says. There's no question his notice in February is clear. I think the other notice is ample because there's a gap even in the timeline as set forth by Mr. Burke, that there was no action taken of any kind to compete, which I disagree that there's the competition. And I attached the affidavits in the addendum about the fact that, the plaintiff refused to do the job. However, I think this is much easier. We just look at the contract. Now, Mr. Burke is correct. It doesn't eliminate his entire case. He might have a case under the Michigan Trade Protections Act in conversion, but if that's it, that's fine. Those are much weaker claims. In fact, in this situation for sure, it changes the complexion of his case completely because this employment agreement is out the door. So without saying any more, Judge, I think that it says what it is. It does. And I think we have to enforce what it says. Thank you.
So, Mr. Carroll, assuming I accept your argument that termination of the agreement is something that either party may do anytime, and that would terminate the non-compete provisions and violation of fiduciary duty or confidential information, how does that get rid of a violation that occurred or a breach that occurred before the agreement is terminated? I don't follow that.
Well, Judge, because the contract says it can be terminated at any time. Does it say it can't be violated after it's breached? I don't see it in the contract. In fact, the non-compete provisions even talk about, it says, subject to the termination as set forth in Section 8. And that was paragraph 11. So while I agree, my client didn't draft this. It was drafted by an attorney that works with Tom's office. That's evidenced as on the bottom of this particular contract. That's what, whether that makes sense or doesn't make sense, it's what the contract says. Anytime for any reason.
So look at what the contract says. You brought my attention to this, paragraph 11. In consideration for his employment, subject to termination as set forth in Section 8, doesn't that at least create an ambiguity as to whether Section 8 means termination of agreement or termination of employment?
Well, what I would indicate to the court is, one, I don't believe it creates an ambiguity, because we also have within the same contract, paragraph 3, that references the term. And the term of this agreement is until it's terminated as it's herein provided. And the only provision that provides how it's terminated, that is of the agreement, is paragraph 8. And paragraph 8 is specific in the words termination of agreement. It doesn't say termination of employment. And that's why I brought to the court's attention other paragraphs that reference the words termination of employment. So they obviously know there's a distinction in the contract itself. And to me, that's what makes it unambiguous, because they've distinguished them.
But the very provision I drew your attention to says consideration for his employment, not in consideration for this employment agreement. And it says subject to termination as set forth in Section 8. That, at least in my mind, creates a plausible interpretation of this agreement that what is being referred to in 8 is in fact termination of employment.
As I look at that, Judge, and I look at paragraph 8 again myself, everything about that termination provision in 3 different places is terminate of the agreement. Termination of the agreement in the first sentence. In the second sentence, this agreement may be terminated. That's by the employer. And then if the employee dies, the agreement shall be terminated. If
So in other, if I were to accept your interpretation, that means there's never any possibility that the restrictions contemplated in 11, paragraph 11, post-employment would ever come to fruition.
so long as the employee took actions to terminate it, correct.
Okay, thank you. Mr. Burke?
Your Honor, I've got 4 arguments. You've basically described 2 of them. The first one is just procedural. This is a C8 motion, and we've gone way beyond that. I assume the court is treating this as a C10 motion because the claim of termination was not brought in the answer, and it certainly wasn't brought in the complaint, which would be all that the court could look at in a C8. But since I sort of presumed it was going to be a C10 and that based on the submission of affidavits, et cetera, that's what I've responded to. Your Honor, I think you read this correctly. It's not clear. I wish it was clearer. Once again, in the contract, it says ambiguities are not to be construed against either party. And that's part of the deal. And you're exactly right. If Section 8 is read the way that Mr. Carroll describes, then that essentially wipes out paragraph 10, which is non-disclosure, which means that all confidential information can be given to anybody else if he just gives 30 days notice that he's terminating this agreement. And it basically wipes that out. It wipes out the non-compete. It wipes out the no interference with employees. So it basically takes out 3 sections, 10, 11, 12, and it also wipes out remedies because there's a specific remedy for injunction, which of course can't happen if Mr. Carroll is correct. So I believe that it's not clear, but we also have evidence that's in the record now, if we're doing a C10, that shows that the defendant Wood did not think that he had terminated this agreement. He still thought he had a non-compete. And if you look at Exhibit B, his text messages to the same customer that he quoted while he was at Centrum months before he talked to him, he says that he needs a release from Tom Monahan, who's Centrum, when he's talking to Grace. Maybe you can get me a release. If he had terminated this deal as expected or as claimed, he would never have said that. He clearly knew that he had a non-compete and that non-compete kept going after he was done. Counsel also knew this. Counsel never brought up that this contract had been terminated by his client in his answer. No affirmative defenses of any relation to that. And so there's evidence that how they're trying to read it now is not the way anybody interpreted it. And I think Your Honor has correctly pointed out, there's places where it's not clear. So we don't think a summary disposition is appropriate. Second, Your Honor also hit on exactly the point that I want to make, is that if we are going to read this contract exactly how it's worded on Section 8, Mr. Wood never terminated it until, in theory, he gave notice in February of 2021 that wasn't effective until 10 days ago. All that time, not all that time, excuse me, for at least 15 months, he's violating the non-compete that was still effective, okay? It's completely clear that when he left his employment at Centrum, he gave a short note that we've attached as Exhibit A that says he is leaving his position. It does not reference paragraph 8 or section 8 of the employment agreement and doesn't say he is terminating the agreement. Therefore, he couldn't have terminated it back in April of 2019. It was still effective until, at worst, 10 days ago. And we believe the evidence is clear that he breached the agreement and the non-compete because we have his text messages. So we think it's clear that he breached it and that my client has a claim for that breach. If he's terminated it now, that's effective essentially 1 month before the 2 years would have expired on his non-compete. However, as the court knows, and as we've argued before, the court has the ability to extend the non-compete period to make up for the time that the ex-employee was improperly competing so that Centrum gets the benefit of their bargain, which is a non-compete for the time. The court has already accepted A1's testimony in their affidavit that they are not building any more of these machines and not competing. But my client would be entitled for the breach that we believe is clear prior to any termination. And we believe that that will be super clear once the depositions are complete and the transcripts. And then all these other issues that were brought up about how the contract was formed, et cetera, none of those were raised in the answer. There's no affirmative defenses relating to fraud in the inducement or lack of consideration or any of those things. And that's all stuff that doesn't really matter to this motion. So we think it's clear that the motion should be denied.
All right, anything further, Mr. Carroll?
Judge, I would it would be as it relates to issues about whether this is competition or not, since the individuals that grazed affidavits indicate the job was refused to be done by the plaintiff. So I'd leave it at that.
All right. I think, first of all, that the scope of the motion goes well beyond the pleadings. So there's no basis for granting relief under C8. As to C10, I think there are genuine issues of material fact that would preclude summary disposition on any of the issues presented. Mr. Burke, you can prepare in order to that effect. But while I got you here, let me ask about this further issue that Mr. Carroll raised with the additional affidavits he sent. Has there been discovery on that as to whether or not the customer involved here was told, we're not going to make this machine for you?
I was going to say, Your Honor, my client testified that no, he told them specifically they would. It would cost them more because they wouldn't do it the way it was originally quoted by Mr. Wood. But that's exactly what the non-compete is designed to avoid, him saying, I can do it for cheaper and leave it at your place. My client denies that they refused to do the deal. I guess there's going to be factual questions on that, but we have two witnesses that say, no, they didn't.
So why couldn't they do it the way it was originally quoted? Well, has there been an answer to that?
Yeah, the answer is that Centrum did not want to do it because of a number of factors that they found out only after Mr. Wood left, and they went and looked at it and said, no, we really can't comfortably do this on your place because there's a whole bunch of fabrication that we have to do, and we need to bring it back, fabricate it at our place. This is a big add-on, 16 feet wide, and then give it back to you. And they said, we don't want to do that because it's too expensive and it's too much downtime. Grays did that.
I got you. So as originally quoted, apparently Mr. Wood was the one that made the quote on behalf of Centrum Force?
Absolutely.
And Mr. Wood was going to do this fabrication on their premises to eliminate the downtime.
That was the original plan, correct.
In the downtown judge, we're
Um,
talking about 8 to 10 months is what the Silvernails would tell you that the plaintiff was trying to tell them.
But our position is pretty simple, Your Honor. It doesn't really matter what the extra expense is. That's exactly what a non-compete is designed to avoid. It's designed to avoid a former employee going out to a customer that he has quoted for the plaintiff and saying, I can do it the way you want it and cheaper. And they say, okay, fine. We like that rather than paying more. That's the
all
competitive
right,
advantage.
I was more curious than anything else. If indeed it were true that the Central Force said, we're not going to do this work, that certainly would impact whether what's being done is actually competition or not. But in any event, that's beyond the scope of today's hearing.
Okay.
I am denying the motion.
Okay, I will prepare an order
gentlemen.
and send it to Mr. Carroll, and then if that doesn't work, we'll submit it under the 7-day rule. I'm
Thank you
planning
very
to
much,
just
Tom.
say for the reasons stated on the record.
Yeah, that's always the easiest way.
I agree.
I can remember.
Okay.
All right, thank you,
Your Honor.
gentlemen.
All right, thank
Have a
you.
good
Have a
day.
good afternoon.
Bye.